Mwatok had lapsed by the time the second motion was lodged. Standing Order 67 of the County Assembly provides for the procedure for the presentation of a motion to impeach the governor. The record shows that the motion by Hon. Michael Ogada was delivered to the clerk on 25th November 2020 and received by the Speaker the following day. Standing Order 67 stipulates as follows. We have reproduced, it's not a long section. Upon the expiry of 7 days, after notice given, the motion shall be placed on the order paper and shall be disposed of within 3 days, provided that if the County Assembly is not then sitting, the Speaker shall summon the Assembly to meet on and cause the motion to be considered at that meeting after notice has been given. Standing Order 67 is titled Procedure for Removal of Governor by Impeachment. This is the law that should guide the County Assembly when deliberating on an impeachment motion. The respondents have correctly pointed out that under Standing Order 49, an impeachment motion is a special motion which has to be disposed of by the Speaker within 7 days of notice from a member. We nevertheless observe that Standing Order 49-2 permits a lesser or longer period as specified by the Constitution, any written law, or standing orders. Standing Order number 67-4 provides that an impeachment motion shall only be placed on the order paper upon expiry of 7 days, and that is the provision to be followed in the impeachment of a governor. Article 259 of the Constitution provides for the manner in which the Constitution should be interpreted. Of relevance to us are subtitles 5 and 6. We have reproduced those two subtitles of Article 259. Applying Article 259.6 to Standing Order 67.4, we find that the notice of 7 days required therein includes Sundays and public holidays. From the record, the motion by Hon. Ogada was presented to the clerk on 25th November 2020 and approved by the Speaker on 26th November 2020. Under Order 67.3, upon approval of the motion by the Speaker, the mover shall give a 7 days notice calling for the impeachment of the governor. By virtue of Article 259.5a, 26 November 2020 is excluded from the 7 days period. However, the 3rd of December 2020 is included. We find, therefore, that the 7 days period requirement was complied with. Standing Order 67.1 requires that the motion be verified and signed by at least 1/3 of the MCAs to confirm that the particulars of the allegations contained in the motion are true to their own knowledge. The evidence on record shows that the notice of motion delivered to the office of the clerk was supported by 86 MCAs who appended their signatures to it. The first petitioner's position was that the motion presented before the County Assembly was not properly verified by the move of the motion as well as by 1/3 of the members of the County Assembly. He submitted that the mover of the motion ought to have affirmed in a deposition the veracity of the allegations made in the notice of motion, but failed to do so. It is alleged that there were no verification forms signed by each of the 1/3 of the members of the County Assembly. We have perused the motion together with a list containing 86 names and signatures of the MCAs who supported it. We note that none of the signatories came forward to dispute the same. In our considered view, by signing the motion, a member confirms its veracity. It will be absurd to expect an MCA to go and swear an affidavit before a commissioner of oaths in support of a motion he/she intends to move before the County Assembly. There is the averment of Mr. Emmanuel Kenga that the first petitioner's advocate, Mr. Evans Ondiek, sent him a list of 88 names with a request for a forensic analysis in order to determine if the list was generated by the same person. We have examined the handwritten list of the MCAs who supported the motion and note that it is the same list sent to Mr. Kenga. According to Mr. Kenga, only 5 entries in the list were made by the same hand. We observe that none of the 5 MCAs identified by Mr. Kenga has disowned the entries. Furthermore, the report by Mr. Kenga dated 12th December 2020 found that all the 88 signatures on the list were all, we are quoting the report, were all written in different styles. They were written by different authors. The above finding by the first petitioner's expert witness leads us to the logical conclusion that each MCA signed against his or her name. In any event, in order to achieve the 1/3 threshold, only 41 of the 122 MCAs were required to support the motion, and we therefore find that the motion had the support of more than 1/3 of the MCAs. Another aspect of that issue is whether two impeachment motions existed concurrently. We note that the order by Justice Ongaya of 2nd March 2020 was to the effect that the Imwatok motion that was scheduled for debate on 3rd March 2020 could proceed as long as there was strict compliance with Standing Order 67 and 72. Our understanding of the court order is that the deliberations on the motion was not stopped, as the court order simply required compliance with the law. For the above reasons, we find that by the time the Ogada motion was presented in November 2020, the Imwatok motion had lapsed for not being processed within the timelines as provided under Standing Order 49 and 67. Another issue is on whether the impeachment motion was supported by 2/3 of the MCAs as required by Section 33(2) of the County Governments Act and Standing Order 67. The petitioners contended that there was no quorum during the deliberation of the motion on 3rd December 2020. Their case is that there was need to have at least 2/3 out of the 122 MCAs physically present in the chamber during the debate. According to the petitioners, this number could not be attained because 57 MCAs were with the first petitioner in Kilifi County. It was also the contention of the petitioners that the gazetted chamber for the county assembly is located in Nairobi, and no member could have participated in the debate if not in Nairobi. The respondents of the contrary view and submitted that the standing orders had been amended to allow for virtual proceedings and voting. According to the respondents, it was therefore not a mandatory requirement that all members of the assembly be physically present in the chamber in order to vote. We note that on 2nd June 2020, an amendment was introduced via Standing Order 231D titled Use of Technology. The amendment enabled the Speaker to conduct virtual proceedings. Standing Order 231D3 allowed MCAs to vote virtually. It is our finding that there was therefore no requirement for the MCAs to be physically present in the chambers in order to vote on the motion. This finding also answers and convinces us to reject the petitioner's assertion that voting is only available to members physically present at the county assembly chambers, where the mace, the symbol of authority, the mace, is located. Additionally, this court takes judicial notice of the advent of virtual proceedings as a mode of conducting business in response to the COVID-19 pandemic, and therefore the physical presence of the MCAs in Nairobi is no longer necessary. We find that while some of the MCAs were physically present in the chamber during the debate and voting, others attended the session virtually. Still on the issue of quorum, the petitioners allege that 57 MCAs who were with the first petitioner in Kilifi County did not participate in the voting. On their part, the respondents argued that logging credentials were availed to all MCAs who subsequently voted virtually. Further, that the petitioners did not provide any expert evidence to support the allegation that the virtual accounts of some of the MCAs were hacked. It is further argued that the identities of the 88 MCAs who voted in favor of the motion and how they voted is not verifiable, hence failing the requirement of Article 10 as read with Article 81 of the Constitution. According to the petitioners, the voting process lacked integrity as accounts of some MCAs were used without the authority. Although the first petitioner averred that he had annexed affidavits of 57 MCAs who claimed that they did not vote virtually, the court record reveals that he attached 39 such affidavits shown by the following MCAs. We have written those MCAs plus their ID numbers. From number 1, I don't have to read the lists up to number 39. In his replying affidavit, the Speaker of the County Assembly annexed affidavits in which 24 out of the same 39 MCAs listed herein above averred that they voted on the impeachment motion on 3rd December 2020. The provided list contains the following names. We have put the names and the ID numbers. These are 24 MCAs ending with Honorable Evans Otiso. So the court is now left with two separate sets of affidavits that present contrary positions. On the one hand, some MCAs averred that their logging credentials were forged and that they never participated in the voting process on 3rd December 2020, and even went to the extent of making a report at the Kwale police station. On the other hand, 20 out of the same 39 MCAs saw fresh affidavits on 4th December stating that they willingly voted on 3rd December 2020. The Hansard, which is the official record of the County Assembly, shows that 90 MCAs voted in respect to Hon. Ogada's motion. In view of the contradictory averments by some of the MCAs who were alleged to have been in Kwale, coupled with lack of an expert evidence to support the alleged hacking, we find that the petitioners did not establish that the 2/3 statutory requirement for impeachment of a governor was not met. It is Stripes law that he who alleges must prove, and it was incumbent upon the petitioners to provide evidence in support of their averment that the 2/3 requirement was not met. Another issue is on the breach of the right to fair hearing under Article 50 of the Constitution. The first petitioner submitted that he was not given a hearing before the County Assembly as he was not furnished with the charges and accorded adequate time to prepare for his defense. Further, that he was not furnished with any evidence to support the purported impeachment proceedings, and that his counsel was denied access to the County Assembly chamber during the impeachment proceedings. The first petitioner further contended that the entire impeachment process was rendered void and invalid since there was breach of Section 3 and 4 of the Fair Administrative Action as well as Article 47 of the Constitution. The second respondent maintained that the County Assembly complied with Standing Order 67 during the hearing of the impeachment. It is his submission that the first petitioner did not inform him in advance that he would send an advocate to represent him during the hearing of the impeachment motion. Further, that Mr. Evans Ondiek did not have any document or proof that he had been instructed to act for the first petition. According to the Speaker, since the first petitioner had been invited to attend the session virtually, the governor ought to have officially notified him that he had appointed an advocate to act for him so as to avoid a situation where the governor disowned the representation by the advocate. Article 47 of the Constitution provides for the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. It also requires that if a right or fundamental freedom of a person has been or is likely to be adversely affected by administrative action, the person has to be given, has the right to be given written reasons for the action. The right to fair hearing under Article 50 of the Constitution provides that every person has the right to have any dispute that can be resolved by the application of the law decided in a fair and public hearing before a court, or if appropriate, another independent and impartial tribunal or body. We have reproduced Section 4 of the Fair Administrative Action Act. We have also reproduced Section 33 of the County Governments Act number 17 of 2012. We have also reproduced County Assembly Standing Order 72, which provides for fair administrative action where there is removal of an officer. The Senate recognizes the right to fair hearing while considering a petition for removal of a person from office under its Standing Order number 76, which we have also produced. The right to fair administrative action under Article 47 and the right to fair hearing under Article 50 have been the subject of several judicial decisions. The case of Ridge versus Baldwin, Appeal Cases 1964, the House of Lords stated that the rules of natural justice, in particular right to fair hearing, or the alteram partem rule, applied not only to bodies having a duty to act judicially, but also to the bodies exercising administrative duties. The House of Lords distilled three ingredients of natural justice as the right to be heard by an unbiased tribunal, the right to have notice of charges of misconduct, and the right to be heard in answer to those charges. In the case of Judicial Service Commission by Mutava, the Court of Appeal, we have cited that case. We have also cited the case of Walid Khalid versus County Assembly of Mombasa and two others. We have also referred to Dry Associates Limited and also referred to the case of Regina versus Secretary of State for the Home Department. We have also referred to County Assembly of Kisumu and two others versus Kisumu County Assembly Public Service Board and seven others. They are lengthy paragraphs, so you will read. As I have said, it will be available shortly. In the Republic versus Clark County Assembly of Baringo, expert William Kamkets, there is a paragraph which states as follows: quite clearly, removal of a speaker must follow a fair administrative action. The rules of natural justice must apply. The office is ring-fenced by requiring disclosure of grounds or reasons for removal, service of notice, and a very high threshold to carry the motion. In light of the above cited authorities, our standing of the law is that the right to fair administrative action applies in both judicial, quasi-judicial proceedings, or any administrative process that affects the right of an individual. As the adage goes, no man should be condemned unheard. It therefore follows that any person or administrative body exercising a judicial or quasi-judicial function must ensure that the affected party is accorded the right to be heard. This calls for the issuance of a notice detailing the allegations against the affected person or persons, sufficient time to make a response, ample time to be heard by an impartial tribunal, the right to legal representation, and where necessary, provision of the reasons for the decision. These are the standards that the Senate and the Nairobi City County Assembly were expected to comply with. Applying the above standards to the present case, we find that the first petitioner was notified of the charges against him through the Speaker's letter dated 26 November 2020. We have perused the said letter, which we observe was accompanied by a copy of the motion detailing the charges leveled against the first petitioner and the list of MCAs who supported the impeachment motion. We note that the motion sufficiently explained the charges made against the first petitioner. Our finding is that the first petitioner was accorded the opportunity to respond to the charges, and that explains why he sent his advocate with bundles of documents to counter the charges. We note that the impeachment process is a quasi-judicial exercise where the MCAs are the umpires. This means that they were expected to make a decision on the motion. It therefore defeats logic as to why the first petitioner opted to ferry the MCAs to Kwale County, yet they were expected to make a resolution on the motion. Instead of joining the proceedings using the link sent to him or appearing in person, the first petitioner opted to watch the proceedings live on television and processed a video to that effect. The first petitioner's actions portrays him as a man who was fully aware of the case against him, but was out to frustrate the impeachment proceedings, and it cannot therefore be said that he was not accorded an opportunity to be heard. Moreover, his action of taking away the MCAs was in clear violation of Section 28 of the County Assembly's Powers and Privileges Act, which provides as follows: a person shall not, by fraud, intimidation, force, insult, or threat or of any kind, or by the offer or promise of any inducement or benefit of any kind, or by any other improper means, influence a member in the performance of the member's functions as a member, induce a member to be absent from a county assembly or a committee at a particular time, or attempt to compel a member to declare himself or herself in favor or against a matter pending before or proposed or expected to be submitted to a county assembly. A member shall not solicit, receive, or accept any fee, compensation, gift, reward, favor, or benefit of any kind for the member or another person in respect of voting in any particular manner or not voting on a matter before a county assembly, promoting or opposing anything pending before or proposed or expected to be submitted to a county assembly, making a representation to a county assembly. A person who contravenes this section commits an offense. In conclusion, we find that the motion, which sufficiently contained the charges, was served upon the first petitioner. The notice period was in compliance with the county assembly standing orders. The first petitioner was clearly informed that he could appear in person or through a legal representation, and was facilitated to defend himself virtually via a link. We are therefore satisfied that the impeachment process complied with the constitutional and statutory requirements. I will let my sister continue. We have about 45 more pages. This is the analysis. That's why we want to read each and every sentence. So my sister will continue from there.
So I will start from the issue of public participation. The first petitioner submitted that contrary to the requirements of the Constitution, both the Senate and the County Assembly failed to ensure public participation in the process of removing him from office. It was additionally the first petitioner's position that it has not been demonstrated that the Senate gave the public appropriate information and opportunity to participate in the impeachment either prior or during the debate. The first petitioner's case is that the removal of a governor is not any other business of a county assembly, and the electorate ought to be involved since a governor is directly elected by the voters in the county. On his part, the second petitioner submitted that failure to subject the removal process to public participation was fatal. He accused the county assembly of not adducing any evidence to show that there was public participation in the impeachment process. In response, the petitioners claim that the principal In response to the petitioner's claim that the principle of public participation was not complied with, the county assembly insisted that there was adequate public participation. The Speaker of the county assembly supported this position. On their part, the 4th, 5th, and 6th respondents were of the view that the requirement for public participation was complied with by virtue of the fact that the proceedings were open to the public. One of the main pillars of the Constitution is the principle of public participation, which allows people to have a say in the manner in which they are governed. This applies both at the national and devolved governments in their legislative and policy functions. Public participation is a cornerstone to democratic governance, as evidenced by its listing among the national values and principles of governance under Article 10 of the Constitution. Article 118 of the Constitution requires Parliament to conduct its business in an open manner and facilitate public participation and involvement of the people in its legislative and other business. Amongst the objects of devolution, as provided for under Article 174 of the Constitution, are to give powers of self-governance to the people and enhance the participation of the people in the exercise of the powers of the state and in making decisions affecting them, and to recognize the right of communities to manage their own affairs and to further their development. Article 196 specifically commands county assemblies to conduct their business in an open manner and to hold their sittings and those of their committees in public, and in particular, to facilitate public participation and involvement in the legislative and other business of the assemblies and their committees. Additionally, the County Governments Act 2012 at Section 87 provides for the principles upon which citizen participation shall be based. These include timely access to information, reasonable access to the process of policy and law formulation, and protection of the rights of the minorities. Section 115 of the same Act provides for mandatory participation and facilitation of the public in planning processes through specified mechanisms by providing clear and unambiguous information on any planning process, as well as developing laws and regulations to give effects to public participation. We considered the case of Doctors for Life, where the principle of public participation was interpreted by the South African Constitutional Court. We also considered the decision in Mui Coal Basin Local Community and 15 others, where the principles were summarized. So the nature, extent, and amount of public participation that is acceptable was discussed in the South African case of Matatiele Municipality and others versus President of Republic of South Africa. And back here at home in Wambora, case at the Court of Appeal, we have referred to it as Wambora Court of Appeal 2, where the necessity of public participation in impeachment proceedings was emphasized. Guided by the above-cited cases on the issue of public participation, we now turn to consider the evidence placed before this court over the same. The first petitioner relied on the affidavit of Mr. Newton Munene Njiru, the Nairobi City County Chief Executive Officer in charge of information technology and communications, to support the argument that public participation was not undertaken. Mr. Munene averred that there was no online platform that could have enabled the residents to participate in the impeachment process. There was no committee report evidencing that there was any public participation at the committee level. He also stated that there was no single FM radio or TV station advert inviting the public to engage in the impeachment proceedings, and that the charges leveled against the governor were not uploaded in the county assembly website. Mr. Munene further averred that the first petitioner's advocates notified him that by 2nd December 2020, about 40,000 memoranda from Nairobi residents had been received by his law firm opposing the impeachment. He averred that none of the memoranda was acknowledged or even canvassed during the impeachment proceedings of 3rd December 2020. We note from the affidavit of Mr. Munene that he introduced himself as the CEC in charge of Information Communication Technology and E-Government ICD Department. His averment was in respect to the executive arm of the county government and cannot be taken to be the position of the county assembly. Indeed, the county assembly in its report titled Public Participation Findings Impeachment Motion observed as follows at part 1.0 of its report, and I'll quote, "It has been noted that the county executive commissioned a separate survey separate from the one by the county assembly. The said survey cannot be the basis of the public participation process envisioned under Article 196 of the Constitution, since it was not commissioned by the Assembly. As such, its findings cannot be relied upon." End of quote. According to the County Assembly, adequate notice of the impeachment was issued to Nairobi residents. Questionnaires were circulated to the residents, and a report dated 3rd December 2020 was prepared and annexed to the Speaker's affidavit. According to the report, the residents were asked if they were aware of the impeachment and if they supported it. The report concluded that a majority of the residents were aware of the impeachment motion, the reasons for the proposed removal of the governor, and that they supported it. There is also the averment that the County Assembly clerk published a notice of the impending impeachment in the daily newspapers of 27th November 2020. It was also the clerk's position that online platforms were opened to enable residents air their views on the issue of impeachment. With regard to the issue of public participation, we find that there is sufficient evidence to show that the County Assembly conducted a survey in Nairobi County seeking the views of the residents. A report to that effect was prepared and tabled before the County Assembly. We further note that on 27th November 2020, the clerk to the Assembly published the impending impeachment motion in the daily newspapers. See, for instance, page 31 of the Daily Nation newspaper, and called for the residents to deliver their representation to the Assembly physically or through provided postal or email addresses. The clerk also informed the residents that they could access the impeachment motion from the County Assembly website, which he also provided. The fact that there was sufficient public participation is indeed also confirmed by the averment of Mr. Munene that at least 40,000 residents had provided their views on the impeachment to the first petitioner's advocate. We take judicial notice of the fact that the current impeachment happened during the COVID-19 pandemic, which severely hindered interpersonal interactions, and some of the avenues of public participation that require physical interaction of the residents, such as public barazas and town hall meetings, may not have been available. From the above exposition, we are satisfied that the County Assembly was aware of the needs for public participation in the impeachment process and indeed complied with the requirements. We therefore find that the constitutional and statutory requirement for public participation was met. Turning to Senate proceedings, the petitioners contended that before accepting the impeachment resolution from the County Assembly, the Senate ought to have evaluated the Assembly proceedings in order to satisfy itself that the law was complied with. They also complained that the first petitioner's preliminary objection was improperly dismissed. The petitioners also argued that the County Assembly was allowed to introduce new evidence before the Senate at the 11th hour. Another complaint was in respect to the manner in which the Senate served the first petitioner with voluminous evidence on the evening of 15th December 2020, yet he was expected to defend himself the following day. It was further submitted that the Senate was biased against the first petitioner and had a predetermined outcome. The first petitioner also contested the manner in which the Senate voted on all the 4 counts, while arguing that it was sufficient proof that the Senate was not impartial. The first petitioner also complained that he was not given the reasons for the impeachment and that no report was availed to him by the Senate. On their part, the respondents argued that all the constitutional and statutory requirements were adhered to in the entire impeachment process. So, starting with the issue of preliminary objection, the first petitioner's case was that he invoked Rule 19 of the Senate rules on removal of governor by impeachment and raised a preliminary objection. According to the first petitioner, He was not accorded an opportunity to prosecute the preliminary objection as provided under Rule 13, and that the Speaker instead invoked Rule 29 and consolidated the preliminary objection with the impeachment proceedings. The grounds of the preliminary objection were that the issues discussed in the impeachment motion were sub judice within the meaning of Senate Standing Order number 98, as they were subject to active court cases, that there was a conservatory order in ELRC petition number 35 of 2020 prohibiting the County Assembly and the Senate from proceeding with any impeachment motion against the first petitioner, and that the threshold for impeachment of a governor had not been met. We have perused the Hansard of the Senate and note that on 16th December 2020, the Speaker indicated that there were two applications. One application was by County Assembly requesting that 11 other witnesses be summoned to